Ladies and gentlemen, there is a breaking news. The Honorable Supreme Court of India today upheld the Honorable Prime Minister Narendra Modi's 2016 note ban decision in a landmark 4:1 majority and opined that the decision could not be faulted just because the center initiated it. The Honorable Court also held that the center's notification dated November 8, 2016 was valid and satisfied the test of proportionality. Reading out the majority judgment, Honorable Justice B.R. Gavel said that demonetization had a reasonable nexus with the objectives, that is, eradicating black marketing, terror funding, etc., sought to be achieved. It is not relevant whether the objective was achieved or not, he added. If you recall that some 58 petitioners challenged the center's decision to ban rupees 1000 and rupees 500 currency notes overnight amounting to rupees 10 lakh crores was wiped out of circulation by the movement. Petitions are good that it was not a considered decision and caused immense hardships to millions of citizens who were forced to queue up for cash. The Honorable Supreme Court also held that the center is required to act in consultation with the Reserve Bank of India, and there is an inbuilt safeguard in the whole system. The judges noted that there was consultation between the two, that is, the central government and Reserve Bank of India, for a period of 6 months. So it was not a decision taken by one individual overnight. The government, while representing the matter, argued that the court cannot decide on a case when no tangible relief can be granted because the matter has already happened. It would be like putting the clock back or unscrambling a scrambled egg. That is what the central government justified the matter. It also said demonetization was a well-considered decision and part of a larger strategy to combat against fake money, terror financing, black money, and tax evasions. While dealing with the matter, the Honorable Supreme Court also held that it is not relevant whether the objective was achieved. Court cannot supplement the wisdom of executive with its wisdom. This is what Honorable Justice B.R. Gavai opined while delivering the order of the 5-judge Constitution bench. In a strong dissenting judgment, Honorable Justice B.V. Nagarathana called the notes ban initiated by the center vitiated and unlawful and said the move could have been executed through an act of parliament. She also opined that the November 8, 2016 demonetization notification was an exercise of power contrary to law. While dealing with the matter, the Honorable Court also held that the demonetization exercise cannot be struck down on grounds of proportionality, adding that the period of 52 days given for the exchange of note was not unreasonable. Friends, this is a very important informations. This is a very important news applicable to all, and that is why we have come out with this video explaining the justifications given by the appellant as well as defendant, and also the final decision of the Honorable Court. If you like this video, please subscribe, please like it and also forward it. Thank you very much.